Good morning, everybody, and welcome to Wealth Edit Wednesday. Today, I'm really excited about having Trish Butcher from the Arch Legacy firm. And we met Trish at the Southern Sea, which y'all have heard us talk about so many different times, but we always meet the most amazing women there. And Trish was one of those, and she just had me being an attorney as well. It immediately kind of piqued my interest on what she was doing. And so Trish, I'd love for you to introduce yourself and kind of tell how you got to where you are today. And then can't wait to go into how you are doing estate and family law a little bit differently. It's really exciting.
Well, thank you. Thank you so much for having me on the podcast. And I'm very excited to be here. So yeah, my name is Trish Butcher and I am an estate planning attorney. And my office is located in Athens, Georgia, so home of the Bulldogs. But I see clients all over Georgia and hope to eventually expand a good bit throughout the Southeast. But yeah, so I am a certified personal family lawyer. And so we do things a little bit differently than like the traditional model of attorney. I certainly don't ever really wear suits. So that kind of sets me apart from the typical stereotype of attorney. But yeah, so I decided to open up my law firm in 2020. I had my son who had just turned 3. And so I was really looking for an estate plan for my family and was just blown away by the fact that in reality, estate plans attorneys really haven't changed their practices in over like 100 years. Like no joke, nothing has really changed. And I knew I wanted to do something different for my son. I knew there had to be something better for my family than just the fill in the blank will. So I decided to jump off the cliff and start my own firm. And I did a 6-month master course in order to get my certification with the new law business model. And it basically teaches a way to truly connect with your clients, become a trusted advisor versus like that one-off transactional attorney, and create a more comprehensive plan. So yeah, just my son. And then also just my dad went through a 4-year probate after the passing of his stepdad and my grandmother. And it was a disaster. It cost so much money. It was just unmitigated stress and anxiety, 4 years of probate in the state of Florida, which is one of the worst probate states. And I just wanted to make sure that that never happened to my clients and their families. So just really wanted to create a new way of looking at estate planning that was going to actually work to keep families out of court and conflict and protect kids, which are our most important assets, are our kids. So yeah, so that's kind of how Arch Legacy came about. And I actually genuinely love what I do. It's very morbid. Obviously I get to hear really sad stories all the time because a lot of times when people come to me, it's like, oh, well, such and such happened to my parents or friends or something, and they want to avoid it for their family. But I truly love getting to meet the families and getting to know them and working with them. And I try and make it as simple and straightforward and not morbid as possible, so that, you know, it's a not so hard of a process and not so scary of a process, which I know it can seem very intimidating and scary for a lot of people when they think about, oh, what happens to me if I pass away? Like no one wants to think about that.
Yeah. I mean, I can't tell you how many clients we see at Somerset where we are working through sort of like all the checklists for a healthy financial plan. And we get to that part of the financial plan. And people that you would feel almost certain had a will or had really thought through setting up trust and things like that, they have not. And then
with some people, that's just really a hard move to make. And so one of the things that I'd love for you to kind of go into, and we talked about a little bit about on the pre-call, was about how often sometimes people are like, oh, well, you just need a will. But really these days, it's a little bit more than that. It doesn't have to be super complicated, but it is more than that. So what are you seeing is probably
Yeah.
the biggest mistake people are making, and then how are you communicating how to change that?
So I think the statistic right now is that about 67% of the population does not have any type of estate plan whatsoever. I think the biggest misunderstanding when people hear estate plan is that they think that an estate means that they have money. So I think that's one of the biggest misnomers of estate planning, myths of estate planning, is that people think that they have to have a lot of money to need an estate plan. And frankly, that's just not true. If you have kids, you have assets. If you're alive, you need some type of incapacity documents. There's a lot of things that go into a estate plan. So yeah, so I get calls all the time, and the first thing out of their mouths is, well, we just need a simple will. Can't tell you how many times that I hear this when I get phone calls, and it's totally fine. And I don't expect people to realize that they need anything more than a simple will, because that's not their job. That's my job. And we don't sit around the dinner table talking about, oh, well, what happens if we pass away? Most people don't do their research before they come to me. That is why they're paying me. So, not a big deal at all, but it is like the number one thing I hear when I get a phone call from somebody is, hey, I need a simple will. Oh, we just have a simple family. We need a simple will. Okay. So last will and testament is absolutely one of the most necessary documents of any estate plan. And it's one of the most legal documents. We don't just sign and witness those. We sign, witness, notarize, and initial every single page. And you have to have the originals when you're filing probate. So they are the most legal documents of all of the documents of an estate plan, but they are not the end all be all. Wills are very important. They're what name permanent guardians for your babies. So if you have children under the age of 18, you really, 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 really need a will, because you really want to name permanent guardians. You do not want to leave that up to a judge. And I don't care if you've named godparents or if you've told such and such that you want them to be your guardian for your kids. If the judge doesn't see it in a legally binding way, judge can name whoever they want to name. So don't let a judge decide who would be the guardians of your children. It is so important that you get to decide that question, no matter how hard it is. And that's what I'm here for, is to help talk through who you would want to be guardian. So you don't have to come up with this on your own either. But beyond a will, a lot of people, there's a myth and misunderstanding that wills avoid probate. The probate process is the process that everybody goes through after they pass away. In the states of Georgia and Alabama, there's only really 3 ways to avoid probate. And that is going to be, if you have no assets, if you have literally nothing to your name, you avoid probate. If you die and you jointly own everything with your spouse, including your house with rights of survivorship, then your spouse can avoid probate. But other than these 2 ways, the only other way to avoid probate is with estate planning, and wills do not avoid probate. Wills are just legal directives that tell the judge what you want to happen during probate. In order to avoid probate with an estate plan, you're going to have a living trust. And I love, love, love living trusts. Not many people know much about them. They're not very well known, but they're so, so helpful for families, especially young families with minor children, because minor children cannot inherit. So if you have named your minor children as the beneficiaries on your 401k or your IRA or your life insurance policy, they will not be able to inherit this money until they turn 18. So the judge will just throw all of those assets into probate. And then the judge will appoint a financial conservator who will oversee this money until your kids turn 18. And then they get a lump sum check for whatever's left. And I don't know about y'all, but if I inherited a lot of money when I was 18, I would have had a really good time at the University of Georgia in our 148 bars that are within the downtown radius. So really important to potentially avoid that from happening. Especially with life insurance policies, which can be a pretty good, lump sum of money. So it's really important to remember that those are assets that are included in your estate. So you can't just think of your estate as what's in your bank account. You have to think of your house, your 401k, your properties, your personal property. If you have guns, we need to take care of those and make sure that those aren't passed on to minors. It's life insurance, it's everything. So the equity of your estate is often a lot more than what you think it would be when we live day to day looking at our bank accounts and paying our credit card bills and things like that. So living trust work basically as a bucket to hold all of your assets while you're alive. That way, if anything was to happen to you, your spouse gets to remain in complete control. If you don't have a spouse, or if something happens to your spouse, everything remains in that bucket. You will have named a successor trustee, very similar to like an executor of a will, but no court process. And the successor trustee can step in and immediately start to take care of all of your assets and your kids without having to hire probate attorneys or go through the court process. It does have to be done right. There are a few more steps to a living trust versus just writing down your wishes in a will, but it's so important. The other things that you would need in an estate plan are financial power of attorney and healthcare power of attorney. Y'all, what happens if you're still alive but incapacitated? Super important to take care of yourself and make sure that your wishes are followed while you're still alive. And an advanced healthcare directive / living will is also a very important document. It's end of life wishes. Do you want to remain hooked up to a ventilator? Do you want to be allowed to pass naturally? So these are all very important documents that you want to make sure are included in every estate plan. The last thing that we include in our estate plans, and you have to be a certified personal family lawyer to be able to include this, is a kids protection plan. And it goes above and beyond just naming permanent guardians. We do emergency guardians, permanent guardians, and minor medical power of attorneys. And even laminated instructions for babysitters. So these are all aspects of an estate plan that a lot of people don't ever really think about to include when they call me up and they're like, I just need a simple will. But again, it's my job to help educate the clients and help them understand what their options are so that then they can choose the best fit for their goals and their family and tell me what they want once they know what all options are and what they do.
Gosh, I love that. That's a wonderful explanation of that. And I think about one thing that you mentioned, I think that's so important. So especially those that are listening, if they decide to contact an attorney, like one of the most important things about that living trust is that the assets are actually transferred into the name of the trust. And I know that you help with that. That's a tremendous service because we see that a lot. We'll get a new client. They say, oh, don't worry, we have all this trust, but nothing has been moved into the name of it. And that really happens a lot. And when you actually start doing that, you realize it is kind of a pain and there are some hoops to be, to jump through. So, but it's just being committed to doing that on the front end. And I love that is part of kind of how you serve your clients. Another question that we get a lot when we are working with a client that is working with an attorney who suggests doing this and they start implementing it, we usually will get in the process of like maybe even changing, names of investment accounts into the trust. Can I change this? Like, how do you talk to your clients about can you ever get rid of that trust if you wanted to put the assets back in your name and not, in the name of the trust? What does that process look like?
Yeah, so it is a revocable living trust is the full name of it, meaning that it is revocable. So you can do whatever you need to do to it while you're still alive. When I explain a living trust to clients, I tell them, you're the grantor, meaning you're the person who puts the assets in it. You're the trustee, meaning you manage the assets, and you're the beneficiary, meaning that you can take all the assets back out and do whatever you need to do. So while you're still alive, all of these assets are still totally yours to do whatever you need to do with. So a lot of the times, when people refinance their houses and it's in a living trust, for whatever reason, either the real estate attorney or the lender just puts up a fuss and makes it easier to transfer it back into their personal names before they refinance or sell. And then we put it back into the trust afterwards. So absolutely, you can, take things in and out, move around. If you work with a good lender or a good real estate attorney, hopefully you won't have to do that. We give really good funding instructions. So we write it all down. They have the instructions with them. A lot of the times, if they work with a financial advisor, which is amazing, the financial advisor can manage most of it. And honestly, they just end up contacting me directly. And that way we can just work together because I really do think it's very much a team effort. And it makes it easier if the financial advisor and the attorney are just working together to make sure the client's taken care of versus the client having to act as the intermediary. Because no matter how well I explain things, oftentimes the client still doesn't know exactly what to say and the right words to use. So love working with financial advisors to get it done. But oftentimes, a lot of the times the client, the only thing they have to deal with is the bank account. Bank accounts are always going to fall on the client. The client has to do those themselves, but we give them everything they need to make sure that they go into the bank with all the documents they need and the instructions for what to tell the bank needs to happen. And if they work with a local bank near us, then most often we have a liaison. So we can give them actually a liaison to work with at the bank, and it will be super easy. If they work with a big corporate bank, sorry, corporate banks are a little bit harder to work with, but it is what it is.
Yeah, it is. And I find that it's getting easier and easier to go through some of these things just as it becomes more prevalent. So, and one question I have for you, and just because we also get this a lot now more than ever, say like a Fidelity, they're giving clients the option to change their account to a TOD or a transfer on death, so that the account transfers directly to, their named beneficiaries. And oftentimes when we are setting up these accounts, we ask the client, is this something you want to do? But more often than not, we will ask for permission to just shoot an email to their attorney, their estate planning attorney, and say, does this work within the estate plan? How does that? So have you seen any problems arise from that?
So
just because I think that's something that our listeners might, if they set up their own Fidelity account, may not know the significance of that.
Yeah, absolutely. And that is one way to avoid probate. So it's absolutely better than nothing. Houses cannot be transferred that way. Right. So that's why houses will always go through probate unless owned jointly with rights to survivorship. But pay on death, transfer on death are great. They are not the absolute optimum. The reason being is that if something happens to you and you're incapacitated and your financial power of attorney is trying to get access to your assets to pay your bills, to pay your mortgage, to pay your taxes, whatever it may be, financial institutions, as far as I'm aware, do not love working with financial power of attorneys. There's a lot of fraud, there's a lot of liability there, and they will put up a lot of red tape. Banks like Bank of America can drag it out for months and years. I've had clients say that they have been trying to get access to bank accounts at Bank of America for years. So what the benefit of a living trust is versus having the pay on death being the living trust, or you're a person, is number one, if you name a person and you have like multiple kids, going to be some fighting there. So not always the best way to go about things. Mm-hmm. If you want them to inherit it in a certain way, that doesn't work. They just get it outright. So living trust, the way they operate is that your financial power of attorney won't only be your financial power of attorney, they will also be your incapacity trustee. So if they walk into the bank and they're going to have a financial power of attorney and they're going to have a certificate of trust naming them as incapacity trustee, and the certificate of trust actually waives the institution of all liability for relying on this document. So there is no liability for the institution in relying on the document and believing that they are the incapacity trustee. So at that point, there is usually much quicker access to your financial assets, to these accounts, versus if they walk in just with the financial power of attorney. So it cuts through a lot of that red tape. It makes the process a lot more streamlined. It makes the financial institution more willing to work with that person. And things are just going to happen at a much more expedited rate versus if that does not in existence. Now with pay on death or transfer on death, yeah, I mean, they're absolutely great things to have, and banks like Bank of America may require that versus transferring the account into the name of the living trust. So better than nothing, but the optimum is to actually have it in the name of the living trust.
I love that. That probably is the best explanation I've ever heard. So thank you. I'm so excited that everybody can hear that. Okay, let's switch gears just a little bit to how you're actually running the business of your practice, because I love the way that you're doing billing with the flat fee. Can you tell us a little bit about that?
Yeah, so estate planning is very personal. We are literally talking about who we would want to take care of our babies. We're talking about our family. We're talking about ourselves. And one thing that does not allow you to create a personal relationship with someone is hourly billing. There is nothing worse than getting slapped with a surprise hourly bill. And clients don't want to talk to you. And I realized that when I was working as of counsel for a traditional law firm, and they hourly billed. And if heaven forbids you went over that retainer, but meanwhile, I'm trying to get to know the client and work through their specifics of their problem. And I want to know the details and get to know them. And I don't want them to be worried that they're going to get slapped with an hourly bill because I talk a lot. Like that doesn't make sense. So I wanted to get rid of that. And on the back end, it is extremely annoying to track your time. I'm sorry, like there's nothing more annoying and frustrating than having to track your time. So
I see another attorney on this call who we talk about the billable hour kills the soul.
the billable hour is outdated and crap.
Kitty, I knew you were
Kitty,
here.
I know you know it. So I do not hourly bill at all. I am a flat fee. I have offered flat fee packages, and this is not something that every area of law can offer. It's just not. But it is something that I feel like with estate planning we can. So we're very fortunate, and it's just another reason that drove me towards estate planning. So I offer flat rate packages. My clients know exactly what they're getting when they get a package. Our base package, our will-based package is going to include 2 wills, 2 healthcare power of attorneys, 2 power of attorneys, 2 advanced healthcare directives, and that kids protection plan for a couple at a $2,000 fee. And they get a lifetime relationship with me. And so I tell all my clients that I'm like, and you get me, yay, congratulations. So fortunate. But that means that they can call me, email me, ask me questions. 3 years down the road, they can call me, email me. They're never going to get slapped with an hourly bill. They are paying for a lifetime relationship with an attorney that they can trust and reach out to and know that they're not going to get hourly billed. And they're going to get comprehensive documents that are personalized to them and their family, and they're going to actually work. So just like walking through the process, like I have design meetings where people get to name all these people and they have lots of questions and they want to talk things out and they want to figure it out. You can't do this via legalzoom.com. I'm sorry. Like there's nobody to help you through the process and help you think things out and, really think things through. And that's what I'm here for. And in order to create that personal relationship, they have to trust me. And hourly billing does not lead to a whole lot of trust sometimes, especially with something like this. Again, I understand that there are sometimes that hourly billing is unavoidable, but for estate planning, I think it is. And I love the system that we've created. And it seems to work really well. And there's sometimes a little price shock when people see my prices. But once they fully understand what all is included, I think it starts to really make sense to them.
Mm-hmm.
But I also try and really be upfront about my pricing ahead of time too, because I don't want to waste anyone's time. And they might not need what I'm offering. They might have a very, 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 very simple, they have one bank account or something like that. And and they don't have minor kids, then maybe they don't need my services. I'm not the best fit for everybody. So I want to make sure that I'm a good fit for the clients that are coming to me. I don't want to waste people's time or their money. That's not my goal.
Yeah. And I think, we went through a similar exercise, Lauren and I did with wealth management. Is kind of this, we really tried to think through like who we were and how we wanted to serve our clients, which I can tell you've gone through that exercise. And I think it is such a valuable, even though it's time consuming, to really spend time on that. And, one of our taglines is that relationships are inefficient and we like them that way. And because exactly what you're doing on your side with that estate planning, we're doing, kind of twofold. Hopefully we're also talking to the estate planning side and that financial side, but with planning, there's no way to do it without like really getting to know them. And having practiced law and had the billable hour model, I did realize like there wasn't a way to do this without like really spending time with them and getting to know them. And it just was such a valuable thing to realize. But to your point, we also had to say it's not for everybody. Not everybody. I mean, I can think of one client in particular who just really didn't want anyone to get to know them. I mean, they wanted that investment and that was it. And the rest of the whole process like made them uncomfortable, and it's okay. I mean, that's right.
And
That's
that's
one
when
thing
you
I
refer
learned.
them to Vanguard and say,
That's right.
Here you go.
You can actually do this yourself and we'll help you. You know what I mean? And so it's interesting I think for me, having like changed careers, I had to like really think through what client do I serve best, and it's like, and I think that applies across the board to all businesses, to like really focus in on what can you do and who do you serve best. So I love that. There's so many things we can talk about, but I want to give you a chance to tell everybody how they can find you and like what states you work in. And then also I've always asked the question at the end, like, why did you say yes to the Wealth Edit?
Yeah, absolutely. So I am, my offices are located in Athens, Georgia. We're actually about to sign a new lease. So technically Watkinsville, Georgia, but like literally like a step away from Athens.
Mm-hmm.
But born and raised in Athens, Georgia. So I'm a native. I work with clients all over the state of Georgia. We even go to our clients for signing meetings sometimes. So we're kind of like a concierge service. So anywhere in Georgia right now is where I'm able to help clients with estate planning. I can do business consulting outside of Georgia, but I cannot do estate planning outside of Georgia. I will get reciprocity into Alabama, Tennessee, and North Carolina at some point. But right now I am unfortunately limited to Georgia. But if you live somewhere else and you would like a referral for an attorney that practices very similarly to me, please send me an email. I'm happy to refer to my other PFLs, personal family lawyers. My email address is trish@archlegacyfirm.com. So TRISH at archlegacyfirm.com. And yeah, and I agreed to be on the Wealth Edit because number one, I love talking to other badass ladies that are just kicking it, killing it. And also just because, I mean, it does correlate so much. I work with a lot of financial advisors. I love helping educate the community. Your wealth while you're alive is so important. And it's so important to learn best practices in managing money. So while I don't really know that much about it, I love working with financial advisors that are really good and really care about their clients. And I can tell that y'all do. So that, I think it's a lot of that same, we're really out there to help our clients. And even if they choose not to work with us, we at least know that we've helped leave some education behind. And but yeah, so it's great working with other awesome ladies that are just killing it and helping to educate the community on best practices. And you take care of the wealth while they're still alive, and then I take care of it out, for after they pass away. So
that's right. Well, I have really enjoyed getting to know you and hearing how your practice is. I want to go figure out who our personal family lawyers here in Alabama. That you've piqued my curiosity. So thank you so much. I hope that we will stay in touch, and I bet we're going to need to have you back on at another time to go into more depth about some of these estate planning terms and documents.
It's a lot. Well, and I will say, I do a whiskey and wills almost every Wednesday where I talk about like little details. Like I pick little things to talk about with estate planning because there's a lot. So, and it's just me sitting here drinking a bourbon, talking about estate planning and dying. So, I try and make it as light as possible. So
where do you do your whiskey and wills? I love that.
Yep. So it's across all my platforms. So the full video is typically posted on YouTube, but I share it to Instagram, Facebook, and LinkedIn, Arch Legacy Firm. So I think it's Facebook, / Arch Legacy Firm. And then it's at Arch Legacy Firm for Instagram and LinkedIn. So yeah, so I posted across the platforms, and it's just a video of me talking about different things to think about when you're planning
I love
for
it.
dying. Because I tell everybody, listen, there's one fact in life, and it's that you will eventually die and pay taxes. I deal with both.
Mhm.
And number two, the greatest mystery is that you never know when or
Yep.
how. So
I love that. Thank you,
plan for
Trish.
it.
I'm going to go follow you right now. I'm join you for a whiskey and Will's. All right. I appreciate
Bring
it.
your bourbon.
Have a wonderful day. Thanks everybody for coming.
Thanks,
Bye.
y'all. And thank you so much for having me.
You're welcome. Bye.
Bye.